This is US History Regents Review. We're discussing Supreme Court cases. This is our third video. We're now going to focus on the actions of some presidents and how the Supreme Court dealt with presidential power. This first one, Schechter Poultry versus United States. This is during the Great Depression when FDR was introducing his New Deal. As part of FDR's New Deal, the National Industrial Recovery Act, one of his laws, was established to allow the president to regulate competition. Schechter Poultry, so they sell chickens, was indicted for promoting unfair competition and then appealed. So basically they were selling some of their low quality chicken at a lower price, but prices had been set. So they weren't supposed to do that. Was NIRA, which gave the president the power to regulate certain aspects of industry, constitutional? The Supreme Court said no. The regulation of interstate commerce is a power given to Congress, not the president. This was a disappointment to FDR because it made the NIRA unconstitutional. The Supreme Court also would declare, would declare the AAA, the Agricultural Adjustment Act, unconstitutional. And both these things are what led to his, quote, court packing scheme, where FDR wanted to add a justice for every justice who was over the age of 70, which would have allowed him to add 6 more justices to the Supreme Court, giving him a ton of power. And he would have put in place people who would not declare his laws unconstitutional. He was worried that his Social Security Act would not be passed and allowed by the Supreme Court. So that was also seen as a breach of executive power, the way that he responded to this court case. The second one is New York Times Company versus United States, 1971. This is at the end of the Vietnam War. The U.S. government wanted to prevent the New York Times and Washington Post from publishing a classified set of documents on Vietnam policy known as the Pentagon Papers. What was actually in these papers was a description of all of the ways that Kennedy, Johnson, Nixon had deceived the public in some ways about the Vietnam War, how they had done secretive things, how they understood that we probably weren't going to win the Vietnam War, and yet continued to send troops anyway. So the president, Nixon, argued that this, would create a national security problem if the public found out about these papers. So he's trying to stop the New York Times from publishing them. So the question is, does the president have the power to stop the publication of historical news that might impact the Vietnam War? Because that war was not over yet. And the answer was no. The papers were historical in nature and did not pose a threat to current policy. This upheld First Amendment right to freedom of the press. The federal government must justify any limits on the press with threats to current or future events. Finally, also Nixon, during the Watergate investigation, where they're seeing if Nixon committed a crime, Congress subpoenaed audio tapes, meaning they officially requested them, and documents that Nixon had kept during his time in office. The president refused to cooperate. Did Nixon's position gain him immunity from the questioning of Congress and the special investigation? The answer was no. He lost this court case and he was forced to hand over the requested materials to the special prosecutor. This is a big deal because it says presidential power is not above the law. He still has to follow the law. Of course, the cartoon over here is showing you that when they did get those tapes, there were 18 and a half minutes missing, just blank. And so people are pretty sure that Nixon tried to cover them up. Either he directly did it or had somebody else do it to destroy any evidence against him that he knew about the Watergate affair. How has the Supreme Court curbed presidential power? These are just a few examples, but we see the Supreme Court sometimes says that the president does not have as much power as he's taking. But if we reflect earlier, during times of war, presidents often gain more power. Other cases you might need to know. Worcester versus Georgia in 1832. So this is back when Andrew Jackson is the president. A Georgia law required all whites living in Cherokee Indian Territory to obtain a license. 2 missionaries refused and were sentenced to 4 years hard labor. So the question is, did states have the power to make laws regarding Indian tribes, like the Cherokee? No, Indians are a sovereign nation. Only the federal government has the right to negotiate treaties with other nations. Georgia laws do not have jurisdiction over the Cherokee. However, the national policy of Indian removal followed. So why do we care about this court case? Well, basically, Georgia had been removing Native Americans, mistreating them, doing other things, and the Supreme Court said that Georgia could not do it. And Andrew Jackson at the time ignored the Supreme Court. He said, like, are you really going to enforce that law? So we see the president ignoring the Supreme Court, just straight up ignoring it. That's going to be a big deal, and is part of the reason why Jackson is really controversial. And he's later the one who signed the Indian Removal Act, which did force the Native Americans to leave and go west. Another very controversial one, Roe versus Wade. This is very controversial today. A Texas woman wanted to terminate her pregnancy, but state law made it illegal, except in cases where the mother's life was in danger. Roe sued, claiming her 14th and 4th Amendment rights to equal protection and privacy were violated. Does a state law banning or restricting abortion violate a woman's right to privacy? For the 100 years before this, abortion had been essentially illegal. The decision was yes, states must allow access to abortion services during the first trimester, but states could regulate abortions beyond that. And this is a current issue because sometimes states will pass laws that go against Roe v. Wade or are trying to limit what Roe v. Wade does. But as of this moment, the Supreme Court has said that women at a basic level have rights to abortions. New Jersey versus TLO, 1985. 2 girls were caught smoking in the school bathroom and were sent to the principal's office. Upon searching TLO's purse, he found drugs and information that suggested she was dealing marijuana. TLO argued that the search of her purse was unconstitutional. Did the school violate TLO's 4th Amendment rights? The answer was no. School officials, unlike the police, only need reasonable suspicion to search students and their belongings if they believe unlawful conduct is occurring. So, on the one hand, we have a court case like Tinker versus Des Moines from earlier that said that students are allowed to have freedoms. They don't lose all their freedoms. They have freedom of speech. They can have political views, etc. But on the other hand, the school only needs reasonable suspicious to search students. So on some level, you have fewer rights as a student when you are in school. The school has a lot of power because it has an important interest in education. So anything threatening educational process can be limited. And there are other court cases that show that as well. And finally, Obergefell versus Hodges. This is a Supreme Court case that is recent and significant. Several states had laws banning same-sex marriages, or that would refuse to recognize same-sex marriages obtained in other states. Same-sex couples sued that these laws violated the Civil Rights Act and the Due Process and Equal Protection Clauses of the 14th Amendment. So the question is, do state laws banning same-sex marriages violate the Equal Protection Clause of the 14th Amendment? And the Supreme Court decided yes. This Supreme Court decision made same-sex marriage legal throughout the United States. So this is a huge expansion of civil liberties for LGBTQ groups. So as you're thinking about your Regents exam, there's a good chance you may have to write an essay about this. They've done this before. You might have to identify 2 Supreme Court cases, talk about the historical circumstances, what the decision was, and what the impact was. You also might need to talk about how they relate to constitutional rights of a specific group of people, like minorities or women, or identify the impact of the decision on Americans.